With all of that being said, I would now like to introduce our presenter, Kendra Dion. Kendra was called to the Law Society of Ontario in 2016 and the Law Society of Manitoba in 2022. As an avid entrepreneur, Kendra studied entrepreneurship in her undergraduate studies, and her solo practice law firm, KLD Law, is her third business she's owned. Through KLD Law, Kendra strives to offer an empathetic approach to wills and estate planning in both Manitoba and Ontario. In addition to wills and estate planning, she also offers a variety of legal services in Indigenous law. We are so pleased to have her here today, and without any further ado, I will pass it over to Kendra.
Welcome, everybody. And it's great to see a bunch of participants here listening today. If you have any questions throughout the presentation, as Nina said, if you can put them in the chat, I will try my best to keep track of them during the presentation, but if I don't get to them during, I'll swing back around at the end. And before we jump into things, I'm located here in Winnipeg, and so I want to acknowledge that we're located here, or I'm located here on Treaty 1 lands in the original territories of the Anishinaabe Cree, Oji-Cree, Dakota, Lakota, and Dene people, as well as the homeland of the Red River Métis. We respect the treaties that were made here, and we acknowledge the harms and mistakes of the past and dedicate ourselves to moving forward in partnership with Indigenous communities in the spirit of reconciliation and collaboration. So, to get started, what I'm going to do is a quick overview of estate planning. Now, an estate plan is an overall plan that contemplates what happens in the event of incapacitation or death. There are some tools that can be used in different parts of our estate plan, and these are some of them. So the main ones we think of are legal documents. Your will is what happens to you when you die. Your power of attorney determines what happens to your property and legal matters if you're incapable of managing it. Your healthcare directive determines what happens if you can't make medical decisions for yourself. And here in Manitoba, they do use the term living will, although in other provinces they don't. You can also hear that being called the power of attorney for personal care. Now, when we're looking at complex assets and unique estate planning strategies, there's all kinds of other tools that we use. In different insurance products as well can be a very effective tool in estate planning, as well as checking for beneficiary designations on investments or other insurance policies. If you own a business, succession planning is also part of the estate plan, and that can be for emergency, but also for retirement and handing off the torch. It's also important to remember that estate planning involves many professionals and different experts. My wheelhouse is the legal side of things, and when I'm working on a more complicated estate plan, it's really important to make sure that we obtain proper tax and different investment advice from the professionals who make sure that that's their specialty. So while I have basic tax advice to give, I always defer to those professionals with those things as well. Same with corporate and commercial matters. I'm going to touch on a few basic topics, but that is not my specialty. So if you have very specific corporate commercial planning, we always want to work in other professionals that can help with that. So before we get going, some common words that you would normally hear me talk about in one of our standard presentations or one of the more basic ones. I know Clea has had several on wills in general. The two big categories we're going to be talking about today will be things that happen in your will and in your power of attorney. We won't be addressing healthcare in this presentation because we're talking about how assets affect your estate plan. So with wills, the testator is the person who's writing the will, or if we're talking about someone who's passed, it's their will. Your beneficiary is anyone you're giving a gift to in your will or through a beneficiary designation. Your executor is the person who administers the estate, and there are some other terms that you may hear depending on the circumstances. If you die without a will, that would be an administrator. You can also use the word trustee interchangeably with executor, but they can also be different. A trust is when you say, I want to give something to Joe, but. The second you say but, that means you want to put a condition on a gift. And so a trust allows you to do that. Now, there are many types of trust out there. Today, we're talking about testamentary trusts, so trusts that are within the will. And your trustee is the person who manages that trust, or it could also be your executor. You could have a different executor and then a different trustee for a specific trust. That's up to you and how you structure the plan. And if you die without a will, that's called intestacy or to die intestate. And in that situation, you have zero control over what happens to your assets. It follows the prescribed division by law. And it varies in each province as well. For powers of attorney, in Manitoba, we use the term donor. In Ontario, as Nina mentioned, I'm licensed in Ontario. Sometimes I go back and forth with my examples. They use grantor for most of their legislation. However, some does use donor as well. And I've seen maker used as a more generic term as well. Now, a lot of confusion comes up with the titles of the document with power of attorney. The document itself is your power of attorney. The person you're appointing is the attorney. Now, in the US, we hear them refer to lawyers as attorneys. Here in Canada, we tend to not use that term as much. Your attorney in your power of attorney does not have to be a lawyer. They simply just have to meet the requirements of being over 18, having capacity as well. They can't be an undischarged bankruptcy, and you need to be able to trust them to make sure that they can do the job. We have a couple of different strategies we can use with power of attorney. And there are many different types of powers of attorney, but a couple of the main ones. A specific power of attorney is one that is for a specific purpose. So I have a client who's going to go backpacking in the mountains for a couple of months, isn't going to have consistent access to reach the family, and they need to appoint somebody to manage their property while they're gone. Let's say if his car is broken into and they need to make an insurance claim, or who's going to make sure the bills are paid while he's gone, and all of those things. You can also use specific powers of attorney for things like business transactions, or in the case of a solo law firm or a professional business, you may have to have a specific power of attorney just for that practice. So I have a general power of attorney for my personal estate and a specific power of attorney for the law firm because my spouse isn't a lawyer, so he can't manage my trust account. So I have to have a lawyer appointed for that. Now, a general power of attorney is your basic one that covers your whole estate. However, on its surface, as it is, a general power of attorney ends when you are incapacitated. What then makes it the tool we need for estate planning is an enduring power of attorney. So you would then have a general enduring power of attorney, and that allows it to continue passing capacity. I've had a few potential clients call me up in a panic and say, oh, the title doesn't have enduring in it, and they're worried that their power of attorney isn't designed to continue passing capacity. It is not the title that matters, it's the clause within the power of attorney that makes it continue. And usually that says something to the tune of this enduring power, general power of attorney is to continue passing capacity. If that's in there, then you're covered for that. We also use springs for different strategies with unique situations and assets, and that's a trigger. So some people, especially spouses, when they do their power of attorney, they may have it effective immediately. Or if we're dealing with a very elderly client who wants help immediately with their banking, those would be effective immediately. But there's many other times where we want it to come into place with a trigger. And the simplest example of that, the one that's in mine, is two doctors certify that I lack the capacity to manage my affairs. Mine is two doctors in Manitoba and Ontario because I go back and forth, but you can customize that however you want. I've also had a few clients who've wanted a specific trigger in there that if they're in the hospital, but they're still capable, that they can trigger the power of attorney to happen while they're still capable as well. So you can put lots of different options in that. So what type of things can complicate an estate plan? Lots. One of the most popular things I hear when someone calls me, oh, my will is so simple. And then we start digging and it's not always that simple. So assets that require special treatment by law, they can definitely complicate things. The biggest and easiest example is firearms, and that's the first one we'll dive into once we get started. Valuable assets that can cause conflict. So that can be art or sentimental things. It may not even be monetarily valuable. It might be that everyone in the family wants to fight over something that's sentimental. Anytime you're dealing with corporate or business assets, you need to take a pause and make sure that that's handled properly. Digital assets are one of the things that are up and coming. And while we have our basic digital stuff like your email, your Facebook, your photos, cryptocurrency can make estate planning very fun or challenging, depending on which way you look at it, and making sure that you understand how those assets would be dealt with. If you have more than one property, sometimes we have to look at the implications of that, whether that be a tax implication or the location of that property. So if it's in another province or another country, and citizenship and residency in another province, country, as well as family members in other provinces or country may change how you structure parts of your plan as well. And if we have time, family conflict and preventing that. Now, family conflict, I could probably talk for 3 or 4 hours on, so I'll try to glaze over some of the basics and things to keep an eye out for. So, what can go wrong with assets? What do we need to think about with assets? Certain assets have to be handled in a particular manner, firearms being one of them. You may need to add extra clauses to your will or your power of attorney to make sure they can be handled properly, especially if you're dealing with, say, a foreign bank or a foreign tax body, like in the States. You want to make sure you have the right clauses in there so that your attorney or your executor have the powers they need to deal with it. Your executor might not know you have a special asset or might not know what to do with them. So that's a chance to have that direction right in the will, right in the plan, so that your executor knows what to do. And if your estate plan is not clear, family conflict is bound to happen. Unfortunately, death brings out greed, emotion, anxiety, and conflict very easily, and a lot of things can unravel very quickly. So the clearer you are, the less likely that conflict is to come up. And of course, taxes and expenses and the implications of those need to be considered because you may have an asset that creates a large tax bill or a large expense, and you want to be very clear who's responsible for paying that, whether it's the estate or your beneficiaries. So, first up, firearms. In Canada, we have very strict regulations regarding firearms, and they are ever changing. So, there are 3 licenses available for firearms in Canada: a non-restricted PAL, which is your basic one for non-restricted firearms, such as most rifles, hunting, that type of thing. You have your restricted PAL or RPAL, which is for restricted firearms, such as handguns fall into that category. There are some other guns that fall into that category as well. And then a prohibited PAL. That is very rare. I've only met one person who has one, and that was the gentleman who taught my PAL course. And that is for very specific firearms that are not available to the general public. The instructor in our course had the same model as James Bond's gun, and the real one is actually too short for being allowed in Canada. And so, with that license, he has that. And it's quite a cool thing to see. So we need to know what category of guns we're talking about when we're talking about firearms, and we need to make sure that your executor knows you have them. You do not want a situation where you're cleaning out grandpa's basement and you find things that you don't know how to handle. Ideally, your executor should have a PAL so that they understand the safety of it. Because not only does the PAL give you that license to possess them, but it comes with a safety course on how to handle them and ensure that they are disarmed, that they aren't going to go off while you're moving them, and how you transport them safely. If your executor doesn't have a PAL, You could also appoint a specific person to handle the firearms that does. So, what I've done before is if the executor doesn't have a PAL, the beneficiary does. We just put a direction that they're to handle that part of it. But as long as your executor is not prohibited by law from possessing firearms, there is a process that your executor can step into your PAL license. And as it stands as of today, that form is the Declaration of Authority to Act on behalf of an estate, and that's found on the RCMP's website. When I'm doing an estate that has firearms, I actually put that form as a schedule so that the executor has it. And while that may change and be updated over time, at least that gives your executor a place to start to look at it. The other thing too that we talk about with wills is sometimes using what's called a survivorship clause. And in most other circumstances, it's beneficial. And what that does is allows you to say that my beneficiaries need to survive me more than a certain number of days before they can inherit. So that can allow you to protect in common disasters. Let's say one spouse passes away today and then one passes away 3 or 4 days later. That survivorship clause would simplify the estate administration. We don't want to use a survivorship clause when we're talking about firearms because you want to make sure that those are handled properly and as quickly as possible. The process itself requires applications and things that take time. And you don't want to be in a situation where there's a restricted firearm in the house. You're trying to sell the house and it hasn't gone through for you to be able to transport or move those. Um, which leads to the next question, can all guns be inherited? No, as the law currently stands. Prohibited, those ones are pretty cut and dry unless you have someone else with a prohibited license. They can't be transferred either. That has been the case since at least I took the course a while ago. But recently, there's been some changes. So non-restricted guns can be transferred and sold. So after death, they can be inherited, they can be sold, they can be transferred. There's just a process where you have to call in with the buyer or whoever's being gifted and get proper authorization to do that. And it's all registered and transferred properly. As of the date of this presentation, Bill C-21 has restricted the sale, purchase, and transfer of handguns. They cannot be inherited unless a very specific set of circumstances exist. So, with handguns and unwanted firearms, they can be transferred to an exempt individual. That exemption list includes anyone involved in sport shooting, and there is a very specific list of who that qualifies for because there is handgun sport shooting in the Olympics, and that is the category for that. So that is also ever changing as these laws develop. So please check that to be sure, as well as someone whose occupation involves the permit to carry for protection. So police, security, that kind of thing, but it needs to be the type that fits into their exemption. So you can't just transfer any handgun. It could be transferred to a licensed business or museum that is authorized to acquire or possess that type of firearm. Many times with museums, they're deactivated, but you have to, again, make sure that you meet those requirements. It does say on the RCMP's website that you can lawfully export it, and those directions are all online. Be very careful with that because you want to make sure that that is handled properly. If you want to keep it because it is a memory, you can also have it deactivated by an approved gunsmith. And deactivation involves two steps, taking out the firing pin usually, and then drilling into it in a way that it will never be able to be activated again. I have a friend of mine whose dad has a matching handgun, revolver, and holster from the war, and it's in perfect firing condition, and it's a beautiful piece of history. And that, as the law currently stands, that will have to be deactivated if they want to keep it. Um, if you don't want the firearm, you can turn it over to the police for destruction and proper handling. But please do not walk into a police station with a firearm. They won't take very kindly to that. Call them to make the arrangements, especially if it is a restricted firearm. there needs to be authority to transport. It has to be handled a certain way. And sometimes the police will assist with that. I know I had a colleague who had someone who, during a separation, they were trying to sell the house, and there was a restricted firearm in the safe, and he couldn't get the authority to transport on time. Like it just hadn't cleared. And so he called and said, "Look, they need this moved. Can you assist?" And they actually went and helped the police transported the firearm to him. So you want to be very, very careful with that. I always put clauses in the will explaining how this should be handled if I'm dealing with firearms, to make sure your executor knows what to do. Collectibles can be very interesting, and that can include anything from art, jewelry, to unique collections, like pop culture stuff or sports collections. You need to first make sure your executor knows you have something valuable. I had a client the other day, one of their prized possession was a small, not a record, a 45 that had signatures and was autographed, and that was their most valuable possession, and it was in a small file. And I said, you need to make sure that that doesn't accidentally get thrown out. And we talked about ways to get it framed and graded and whatnot. So make sure they know that it is valuable. It's also helpful if you have large collections to have things appraised beforehand. Recently working with a client with a large collection of jewelry and making sure it was divided fairly, or at least relatively fairly. And we had appraisals, descriptions, and values of every piece. So we were able to use the description in the appraisal along with photos to say, these are the pieces going to this person, these are the pieces going to that person, and so on. The other thing you can do is state that your estate should bear the cost of that appraisal, as well as insurance, storage, and shipping. Recently had the pleasure of seeing a very interesting pop culture collection, including set pieces from different shows, masks from different character makeup, and all kinds of collectibles like that. And they want to make sure that it's insured, it's appraised, it's stored, and that the estate bears that cost, rather than whoever's getting them. You also need to make sure that your items are still valuable. Remember the Beanie Baby craze? When I was a little girl, I thought that was going to pay for my college, and I learned very quickly that they're no longer valuable, and luckily passed those off to a children's organization because they were way more valuable to the kids. Another thing I've seen recently is the old Country Roses dishware, because they used to be very expensive and very valuable, and they're very sentimental to certain generations. But as the younger generations tend to not admire fine china as much, I've heard that there are not very many places that will take them, and they are actually quite hard to sell. So they're not as valuable as you may think, unless you have a buyer or an appraisal or a specific market to get that thing. You also want to be very clear about what happens if it cannot be agreed upon. So, saying my trustee has discretion to distribute my jewelry to my family could cause conflict. I did recently with this one with all the collectibles. We had a couple equal value assets. And what we did was, here is lot one, here is lot two, here is lot three, three children. If they can agree who gets which lot, great. If they don't, this is how we deal with it. So each lot numbers to be drawn basically to see who gets which lot if they cannot agree. Also had a wonderful client who already had a plan. She had was in a band with her husband, and they both had guitars. He's passed, and her two children don't get along, and she knew they both wanted dad's guitar. And she said they are identical in appearance, they are identical in value. It is they don't know which one was dad's guitar, and she said she was going to go to her grave as the only one knowing which was which, and if they couldn't decide who got which guitar, they were to flip a coin. The more you clarify how we deal with this stuff, the easier it is for your executor down the road. If you have a business, corporate assets, or any sort of business interests, we need to be really careful as well. Sole proprietorships are structured so that the owner and the business are one and the same. That may not require a separate will, but depending on the plan and the situation, it may. Corporations also need to be considered because it is a separate legal entity. So you need to determine whether you can deal with that in your personal will with the shares of it, or whether the corporation itself needs its own will, or if you need separate wills to deal with separate assets. Now, here in Manitoba, we don't hear the use of multiple wills as much as some other provinces. In Ontario, there's usually the strategy of having a probate will and a non-probate will because Ontario has estate administration taxes. And so that concept of multiple wills is taught in our courses regularly. But you can come up with as many different ways to plan for these type of things as there are options. Family business is very important if you intend your children to take on the business. And so not only do you need to consider the will and power of attorney and things like that, you need to consider an overall succession plan for passing the torch and for retirement. And for any of you who have watched the television show Succession, I'm in the middle of the first season of it right now, and it is a perfect example of everything that can go wrong when someone is hurt or ill or potentially mentally unwell. So you want to make sure that you know where that's going to go with a family business. And of course, if you have a business with a professional obligation, you also have to consider what those are as well. So, as lawyers, as sole practitioners, we have a duty to have a plan in place if something happens to us, which is why, as I mentioned earlier, I have my general power of attorney and my specific power of attorney for the law firm. Same goes for the wills as well. For me, I'm going to have three because I practice in both provinces. So it'll be my general will for my personal property, my Manitoba will for my legal practice, and my Ontario will for my legal practice. Making sure that each of those are handled properly and what happens if I'm hurt. So in my personal power of attorney, the standard is two doctors certify that I lack the capability to manage my financial affairs. My business one, the threshold is unable to work. So I may be capable, but I may be unwell. And if a doctor certifies that I'm unable to work, then it triggers, and the lawyer I have listed on mine can step in and take care of my clients. Same can happen with doctors. Uh, a while back, one of my medical professionals had a heart attack, and they had a phenomenal plan in place for what happens and which doctor was to take over for them. And fortunately, 3 months later, he came back. He was fine, but he had everything in place in case something went wrong. So there was no interruption for patients. There was no stress on our part. We knew who we were being taken care of, and he could take care of his health and not have to worry about the business. Digital assets can also be very interesting. And I always bring digital assets up to all of my clients at a basic level when we're talking about things like email, social media, photos, personal data, and accounts, because it is something that needs to be planned for. Something as simple as your executor not being able to get into your email account is very important because that email account could show them bills that they don't know about. Like, who is the phone company? Who is the internet company? Is, is there a cell phone we have to deal with? Are there subscriptions, especially nowadays with so many online subscriptions? You don't know, do they have Netflix, Disney, YouTube, all of those things. And so with Gmail, for example, there are specific settings in your Gmail account where you can determine what happens to your data if you're inactive for a certain period of time. If you're looking for more information on that, I do have an article up on my website with the step-by-step instructions. But essentially, what happens for mine, I've got it set at a year. If my account's inactive for a year, it transfers to my executor, which happens to be my spouse. It gives you a million notifications if you start to become inactive before they transfer that. So it does give you control. The other option is to ensure that your executor has some way of getting to a password or passwords that they need. That doesn't mean giving it to them right off the bat. It could be that they're in a safe and in an emergency, your executor has access to that safe. Never give your passwords to lawyers. We are taught not to take them and we do not want them because they change and we don't want access to your accounts in that manner. When I'm working with my senior clients, the other option is if you have a young person who assists you with your technology. I say this because I have a couple that are very dear family friends of mine, and they call me their 30 some and I'm their fix for technology. So they'll call me up and say, "What's my Netflix password? I'm at a hotel and I can't get it to work. What's my Peloton password?" And I have their passwords because I help them create their accounts. So making sure there is some way to access that. The other thing that's really important is things like Facebook and your social media and making sure that it's set properly and that you know how you want that handled when you're gone. This same family friend, she lost her daughter years ago, tragically, and it was the husband that was the executor, and they chose to keep the Facebook account active and they still post on it. So my friend sees her deceased daughter posting on Facebook regularly, and that's quite traumatic for her. So you want to make sure that you say, "This is how I want that handled." Cryptocurrency is an ever-growing world, and there are many digital assets that are similar to crypto that you need to consider. Regulation is very different everywhere when we're talking about crypto. But the one thing that does stand is that cryptocurrency is an investment, and whether or not it's here in Canada or however you deal with it, if you sell it, there will be capital gains counted, and it is counted as income. So you need to make sure that there is a process and a plan for how that will happen and whether or not tax planning needs to happen for that investment. The other thing about cryptocurrency is, and you see lots of things on the news about some like, you know, money being lost because the code is gone. The Quadriga debacle is a whole source of a book for if I've got any other legal professionals on here. There's a great book on digital assets that follows a crypto example with Quadriga and what happened when the owner disappeared and how that got unraveled, as well as MT Gox when that disappeared. That lawsuit is still ongoing for what happened with that exchange. So you want to make sure that your executor knows how to locate and get to that crypto. Another not so fun example, my spouse is very involved in cryptocurrency, and he's told me if anything happens to him, it's my responsibility for gathering all of that. And I know the theory of it, and I know that I could figure out how to do it, but he's not actually showed me step by step, this is what you do with this code. I know that, this is where it's stored, this is the location. If I ever need to access it, I'll have to find someone to make sure that I don't mess up. But if you're dealing with someone who's not technologically savvy, I recently had a client in Ontario who had a lot of crypto. It was a two-page clause breaking everything down and what to do with it. And I said to him, I said, "I know your wife doesn't have a clue how to work this." And wife's sitting there nodding next to me. And I said, "You need to make a book with instructions on what to do for this because it is not just one type of crypto. It was a lot. I don't even remember how many it was. It was at least 20 or 30 different types. And he buys and trades and sells and plays with it as a bit of a hobby. And so it was so vast, the type that we had. So we need to make sure we plan for that. People don't think about online gaming and gambling accounts. World of Warcraft and some of those other video games, you can use real money to purchase things in game. And a lot of people who are very uh, involved in those games spend thousands of dollars. And whether or not that can be transferred, whether that goes anywhere, whether there's any money that hasn't been spent on those accounts, all needs to be thought about. And each platform has their own rules. Gambling accounts are another thing because if you may have debts or you may have a large balance that needs to be transferred out of there. And then, of course, the other category we have are websites, domains, intellectual property, and things like that. So if you have a business, what happens to your web presence? If you are an artist, what happens to that, or any manuscripts, written work, any form of intellectual property could be in a digital format, and you want to make sure that you plan accordingly for that. The other thing too is if you have a domain or you have a website and your executor doesn't know how to handle it, you need to make sure there are instructions. Again, referring to my family friends, they are both seniors, and the husband is fairly technologically savvy and has his own custom email domain and this and that. And it's not on one of the regular platforms that we create websites in nowadays. And I said, I don't think your wife knows how to handle this if something goes wrong. And again, she's nodding. And I said, we need instructions on what to do. How is this paid for? How is it managed? Because we don't want her getting booted off of her email that's under the same domain. Cottages are fun. Uh, I don't know how many times in courses as well as working with clients that we hear that cottages can be very complex and that sometimes too much conflict can come up when we're dealing with them. So we need to consider whether it really is the best decision for it to be split amongst many children. If it's one or two kids, a little bit easier, but when you start saying we've got 4 or 5 kids. If one of them predeceases, they've got 3 or 4 kids, and we want the grandkids to be able to use the cottage too. Then we really have to think how we're going to structure it. So here's some questions to get you thinking. Where is the cottage located? Is it close? Can everybody access it? Will they want to access it? Is it in another province? Does it fall under, do we have to then think about multiple wills or how probate will go? If it's, say it's in Ontario, for example, do the kids even want it? How will you structure joint ownership? Because if you're structuring it in joint tenancy, then that right of survivorship is there. So it makes it harder to plan to get it to the grandkids. If it's tenancy in common, how will we deal with that? And are you going to be in a situation where you have 20 shareholders, like people with shares on this cottage? Now we're getting complicated. Who's going to pay to maintain it? Who will they, how will they decide who can use it? Think about you're here right now, and if someone's fighting over somebody had bad weather and they canceled their weekend, now they want a new makeup weekend and everybody's fighting, and you're here to help them. Now imagine what happens when you're not. What if someone doesn't pull their weight and doesn't pay the bills and the others are on the hook for it? Are there any tax implications of the transfer or the sale, and who's going to be responsible for it? I was recently on a panel with a financial planner, and the two of us were talking about common mistakes, and this was the example she gave. It was a situation where mom had an RSP valued at X amount. Well, let's just say 500,000 for an easy number, and a cottage worth 500,000 in Ontario. Also, mom was in Manitoba, so we get complicated already with that. Well, she thought I'll leave the kid in Manitoba, the RSP, and I'll leave the kid in Ontario, the cottage. Well, the RSP had a beneficiary designation. It automatically traveled to that child. Whereas turns out the cottage was built from scratch. They had it for years. It had a substantial gain in value over the lifetime, and it didn't fall under a principal residence exemption or anything like that. And there was a $150,000 tax bill owed, plus estate administration taxes for Ontario, and the nightmare continues. So now one child has gotten a very large gift with no implications, and who's on the hook for paying for this cottage? So you need to make sure that when you're planning for things like this, that if you want equality, equality is what actually happens. And that's our job as lawyers to look at that and say, okay, well, if you want it divided this way, why do you want it divided this way? Do you want it to be unequal? Who's going to pay those bills? Sometimes it's, well, let's sell the house, but if anybody wants to buy it, they can, and they're on the hook for all the expenses and whatever. Or I want the estate to pay for any of the capital gains tax, but maybe these fees might not be covered. you can create a trust in order to have that cottage there and to pay expenses and things, but you need a substantial estate to be able to make sure that you can cover those costs. Um, so in the end, it may end up being simpler to have the cottage sold, especially if you know they're not going to agree. If everybody wants it and everybody's going to fight over it, there may not be an easy way to do it. What can also get messy is if the property's in another province or country. As I mentioned, Ontario has probate taxes and we don't. So we need to make sure that that's accounted for and that it doesn't impact your overall estate. It only deals with the asset in that jurisdiction. Um, you also have to consider that every province has different estate legislation and rules, and they may have different requirements for a valid document. So here in Manitoba, one of our witnesses for a power of attorney has to be one of the ones listed in the legislation, lawyer, cop, doctor, judge, notary, etc. Whereas in Ontario, the requirement is just two witnesses. It doesn't have to be one of those. So if you're dealing with property in another province, you need to make sure your POA and your will cover everything that's necessary. Now, if you're in a different country, you need to make sure that you understand the laws of that country. The United States has very, very complicated tax and estate rules, and you need to make sure that you understand them and whether or not they apply to you. So if you're a snowbird and you have a property in Florida, you need to talk to someone in Florida. And not just a US lawyer, you need to talk to someone in the state that your property is in because they have both federal and state laws, and they are all very different and very complicated. You also need to know if the country your property in has specific estate rules that dictate what happens to that property. There are some countries, I believe in Europe, that still have forced, is it forced airship is the word, I think, where there's a certain breakdown of in the law of where things go, and you have to do things to get out of that if you're not a citizen there. Um, so make sure you're very careful with property that's outside of Manitoba and outside of the country. But sometimes it's not your assets, it's the people that can start to make things complicated. Citizenship or residency in any other country can affect your estate in a couple of different ways. If the testator has citizenship in another country, you need to consider if there's estate taxes or fees associated. The United States is one of, I believe, two countries in the world that has estate taxation solely based on citizenship. My spouse is dual citizen, so even though we've never lived in the US, he would have to be subject to the estate taxes in the US and the reporting requirements, as well as income tax. Now, when it comes to estate taxes, there is a cap. So if you're under that cap, you you won't have to pay the estate tax. Um, but that cap is changing, and you need I believe it was only set for 4 or 5 years, and whether or not that gets reviewed, you need to double check. Renewed, sorry, you need to double check. Executors should be in the country and should be in the province that you're with. Um, there are ways to structure it, but it is not advisable. I did have one client whose only child lives in Australia, and because they're part of the Commonwealth, we can do it, but there's going to be complications. They will have to pay that the bond or surety requirement to go through probate. They may have to hire someone here to do a lot of the footwork because they're not here to do it. You don't want to touch an executor in the US. If you have US citizenship or residency, how we've done it with the Canadian side of things in the past is puts that US person as an advisor to the executor to make sure the US stuff is covered, or have a US will in that state to cover your US property and your US obligations. Beneficiaries in another country usually aren't that complicated. You just have to make sure that you plan for them. If there's a trust So let's say you have grandkids in Australia, to continue with that example, you need to consider if there's a trust for them where that will be resident for tax purposes. And that can vary as well if your trust is resident in a different province, if you have an executor out of province. And you need to think about travel for your executor, or getting things or shipping them to beneficiaries if they're in a different country. It's one thing if you're giving a foreign beneficiary money versus all of the assets in the house and whether or not they want those shipped. Um, and to talk, I know we're getting close, so I'll probably keep going till one and then answer some questions afterwards. And I haven't seen any pop up in the chat yet. So if you have your questions, keep having them come in. Family conflict can come up with so many different things. And so it's really important to create an estate plan to minimize that conflict and simplify estate administration. What type of things can bring up conflict? Mostly anything, but thinking about whether or not you want multiple or joint executors or attorneys on the power of attorney side. um, if you have joint executors, they need to agree, or you need a mechanism for what to do if they don't. So that can get complicated. You have different ways you can appoint them. Being successively means to have one, and then if they can't act, another alternate. If they can't act, another. That is the cleanest way to do it. Um, but you could also do joint appointment where they must all agree, or joint and several appointment where they may act together or alone. Being careful with joint and several appointment because the left hand doesn't know what the right is doing, or there's a risk of that. Also, too, when we're talking powers of attorney, be very careful with joint appointment, as there are some financial institutions that won't accept joint and several appointment, and land titles here won't. However, Ontario does. So you want to make sure if you're crossing province and you're dealing with joint appointments for either the executors or the attorneys, that you've considered all the options for that and it's the best option. Some people may also say, hey, I don't think my family could deal with administering my estate. I'm going to go in a completely different direction and have a friend or a company or someone else manage it. You also want to be careful with trustee discretion and giving them the power to distribute things. Because if you just say, my trustee can distribute my jewelry amongst these people, what happens if they disagree? You want to balance whether or not you're going through the process of listing every single thing, which you don't want to do. Like, you don't want to have a 16-page will listing every single little item unless it's necessary, versus being too vague and there being dispute. So making sure that we pick out the things that are most debatable. And 9 times out of 10, I'm at someone's house because I go to clients' houses for their consults, and we have a pile of jewelry on the table, and I'm writing out the descriptions of them, or they have appraisals or things that give me those descriptions. And we decide, okay, what are people going to fight over? Because they may not be worth anything financially, but everything sentimentally. In my family, my great grandma makes made beautiful quilts, and if I passed before the other women in my family, they would probably kill each other over who gets these beautiful quilts. So I have listed that in mind because I know that's a, hard topic that everyone would fight over if something happens to me before them. You also want to avoid trusting that your child will do the right thing. It seems very common for someone to say, "Oh, I just want to leave it to this one and let them deal with it." Or this child is joined on the bank account, so they'll distribute it to everybody else. Unless you have it specified that it creates a special trust or there's a way that it's done, there is no legal obligation for someone joined on a bank account to distribute it to everybody. And that is a huge risk. So you want to make sure that you are spelling out what you want as opposed to trusting that the one child will be fair to the others. And be very clear on your wishes and what your intentions are. If it is your intention for the estate to cover expenses, say it. If it is your intention for the beneficiary to do it, say it. If it's your intention for certain things to be done, explain it. You want to make sure that you're clear. and that you get the right advice on all of these different circumstances to make sure that your estate plan simplifies the process for your family. So when you meet with a lawyer and you're starting this process, and it is actually most of the same questions when you're meeting with, say, a financial planner, we start with what do you have? I myself have a questionnaire that we go through, and then I walk through all the different categories of assets to make sure we haven't missed anything. You need to prove who you are, so government issued photo ID. I'll look at prior wills to make sure that I'm not missing something or there isn't something in there that we haven't talked about, looking at insurance policies and the beneficiary designations, checking how the pensions are set up, information on bank accounts, investments, and the way those are structured. Marriage and separation agreements to make sure that you don't have an obligation because some separation agreements say, this certain amount of support is owed for a certain period of time. And if they die before that obligation is fulfilled, then the obligation needs to go in their will. Flip side of it, separation agreement may say they don't owe me anything in their will, and it's important for us to know that. And then, of course, all the detail and information on these important assets. If you have a cottage, have that information ready, especially if it's a unique situation. Like there are some places where it's set up like a trailer park where the land is rented, but they own the building on top of it. Making sure your lawyer understands how all of that is structured so they can make sure that they do the right thing in your will and in your power of attorney and the rest of your estate plan. And with all of that, I've come 5 minutes under as well. I don't see any questions in the chat, but as they come in, I'm happy to stick around for a little while longer to answer. And you can always follow up with other questions with Clea or as well with me as well.
Thank you so much for that presentation, Kendra, and thank you to everyone who attended.